Welcome to this forum, the first forum of 2026. I'm delighted to say that my dear friend, Mr. Robert Kelly from Stewart Title, is in attendance today. Robert, as ever, lovely to hear from you and to work with you, and delighted that Stewart Title are supporting these forums as ever and supporting IQ legal training. I think we've got a conference next week in Northampton, haven't we? And then we've got one in Newcastle. We're all over the place with conferences, etc. Anyone that's interested in attending a conference, they are free. They're sponsored by Stewart Title, and you're more than welcome to come along. We've also got lots of CPD events during the course of the year, lots of conferences up and down the countryside, sponsored by Stewart Title, which again, you're all welcome to come to. But in the interim, Robert, first of all, thank you for joining us this afternoon. I'm happy to manage the slides. Would you say a few words about your work at Stewart Title, indemnity policies that you can offer, and assistance that you can provide?
Yes, certainly, Ian, and hello to everyone. And just to reiterate what Ian said about the conferences, the road shows, they are an incredible chance to get a lot of knowledge in a short period. You obviously have Ian and other guest speakers talking about important topics, but also then some very detailed notes afterwards. So it is a real resource for you, and I heartily recommend that you come along. You can also pick up some chewy sweets and pens from us, which is the real reason for turning up, I'm sure. But other than that, obviously, it is a dark day in title insurance today, as we are seeing the end of ground rents, excessive ground rents, which means our ground rent policy will soon be a thing of the past. But actually, very delighted to see that this is a move that can help both your clients and you get on with things. So we'll have to talk about some new policies. Ian and I were just talking about whether there's an angle for common hold, whether there's any risks and dangers there. So as Ian researches further on common hold and does our series of talks on it, we will be looking to see if there's any gaps there that we can fill. But in the meantime, Stewart Solution, our online ordering system, still has over 150 different risks on there. You can get up to £20 million worth of cover immediately online. All of our policies contain 10% inflation cover for each of the first 10 years. So if you buy a policy today for £500,000, at the end of 10 years, it's over £1 million worth of cover. And that should hopefully deal with most inflationary increases. If there is any further increase, or if your clients improve the property, then you can always get a top-up policy. Reason behind Stewart Solution is to give you the power and comfort of an insurer. We are the insurer. We back this up with our funds in the UK and in our parent company in the US. So it is a guarantee for payment there. And a very simple system, 3 steps to get a quote, literally less than 60 seconds. If you are interested in having a look at it, I'll share some details with you later. Obviously, some risks can't be done online, where there's a degree of development or planning work, or where the amount of cover you require exceeds that available online. Then our highly experienced underwriting team are ready there to deal with those. You can instruct them directly, or you can start a quote online. And then if you think you need more help, you can go through to the underwriting team there, and you can upload documents and plans to help you. As Ian said, we do sponsor the road shows going around the country. I think we've got 9 or 10 of them this year, Ian, haven't we?
Yep, we have. Yep.
And so details of those are always available from the IQ legal page. We also run these monthly residential property forums, and also one for commercial property as well, both of which, as you'll know if you've attended any of them, a really useful way for you to not only get Ian's knowledge, but also the experiences and knowledge of your peers. We also do in-house training sessions for law firms, particularly about regulatory matters. Despite the fact we try to make title insurance easy to order, it is a regulated product. There are regulations contained in the FCA handbook which you need to obey. We can do your training on those, and also on general areas, really about how you can explain title insurance to your clients to make sure you're giving them the best and proper advice. Go to the next slide, Ian. So these are the details. If you are interested, if you'd like some details of Stewart Solution, you can go to that site there. You'll be sent login details. You can go in, have a look around. There's no obligation. We don't have your bank details. We don't take money from you. If you order a policy, then you'll receive an invoice at the end of the month. But your login details remain valid forever. You can go back in any time when you think you want to check what is available. And also, we do have a quick quote function on there. So in less than 10 seconds, you get an indicative quote. For other matters, particularly about the spoke team and so on, please contact the business development team address there. And also contact that if you have any colleagues who are transacting business in Scotland and Northern Ireland. So we do have a presence there, and we will be running some training sessions on that this year as well. And if you have any queries about training we can do for you or your firm, either remotely or come in-house to do it. Obviously, we come in-house, then you do get the suites and the pens, but online is also available. So please contact me if you want those. And then otherwise, Ian, I'll hand over to you for what looks like a very packed programme.
It is. Thank you, Robert. Robert, I didn't mention to you earlier today that yesterday I was in Bristol and there was a firm of solicitors singing your praises. They use you and one or two of your competitors, but were singing your praises over and above your competitors, which was nice. I didn't, it was, the information was volunteered to me, but I thought I would convey it to you. And again, as far as anyone attending today, two things that I think are important about Stewart Title. One, Robert, you'll confirm, no fees payable. You can just log in, or you can get login details and purchase a policy sort of as and when necessary. And the other thing is that you may have an existing insurer that insures risks. From time to time, you might come across something that's unusual or obscure, or you might want a quote with regard to, I don't know, a high value policy. Do contact Robert or his colleagues at Stewart Title. They may be able to offer you an alternative, or may be able to deal with a problem that perhaps your existing insurer can't deal with. So contact Robert, make a note of his contact details there. To be honest with you, I'd sign up so that you can use the facility as and when necessary. There's no obligation to use it. Robert won't harry you and ask you what's happening. One of the things that Stewart Title does, which really impresses me, is they're really professional about how they approach people. So, happy to provide a service, but I'm not going to harry or bombard you with emails, etc., or anything like that nature. Anyway, massive thank you, Robert, and a massive thank you to everyone attending today. As usual, with regard to events such as this, I always like to throw in some useful websites. Talking to some at the firm yesterday about complaints, etc., complaint handling. The Legal Ombudsman site is useful. Those of you that are not familiar with a site called Property Law UK, this is our monthly electronic publication that comes out each Wednesday, the last Wednesday of the month, and is a really fantastic resource. I think there's over 100 pages of articles, case law, etc., written by a number of guest editors and contributors. I think I've written something this month about liability relating to trees on land, and highway authority liability for trees on the highway, etc. Loads of other case law that's written about, and you can access it. It is a subscription service. If anyone's interested, let me know. And we've just acquired a website called legalmortgage.co.uk. I'll just put it in the chat box there. This is a site that is free to access, but contains a wealth of information concerning mortgages, residential mortgages, commercial mortgages, case law relating to it, etc. Really excited about it. It's free to subscribe to it. Just go on the site and connect, and you'll get a newsletter. The first newsletter that we've been dealing with is the January newsletter, which will be out sometime this week. And as I say, it's a free resource, and I'm delighted to say that Stewart Title are sponsoring that resource. So a massive thank you to Robert Kelly and colleagues for getting involved in that. It's a new thing. It was originally a website created by our friend Nigel Clayton, who's a barrister at King's Chambers. Nigel's sort of not retiring, but taking life easier, and we've agreed to take it over because it's such a fantastic resource. Anyone interested, have a look at the website or message me, and we'll make sure that you've got all the appropriate connections, etc. Anyway, topics, as Robert said, lots of stuff to talk about today. First of all, a few conferences, etc., I've been attending recently and talking to attendees about boundary issues and boundary problems. And again, just making sure that residential conveyancers are aware of the fact that they should be setting realistic client expectation with regard to boundaries. What they need to do is make sure that they are ensuring that clients understand that the conveyancing process is pretty imperfect at identifying legal boundaries. And therefore, if there is boundary sensitivity, so if your client wants to build as close as possibly as he can to the western boundary of his property, or there's been a dispute with regard to a garden fence or a wall or something of that nature, the conveyancing process is unlikely to identify the legal boundary sitting between two registered titles. The reason for that is Section 60 of the Land Registration Act 2002, which states that the Land Registry will define a general boundary, not a legal boundary. The other problem that you've got is a Land Registry title plan is normally insufficiently precise to be able to and to enable a boundary to be identified. And the other problem is that normally a legal boundary is identifiable by ascertaining what was intended when the boundary was created, and finding that intent either in the document that created the boundary, the conveyance or transfer or contract or lease, can be difficult, if not impossible. And even if we're able to do that, the next difficulty is trying to ascertain where in 2026 the boundary that was created in 1898, where that actually sits today, because often it can be quite difficult to identify physical features or other features that were described or utilized in creating the boundary in the first place. So be careful with that. Next question to watch out for, the revised TA6. Yesterday I was with a firm and we spent about an hour and a half talking about the problems with the revised TA6 and TA7 form. Remember, the revised TA6 form will have to be used by you if you are to be CQS compliant as of March of this year. Firms that I talked to still haven't amended their retainer and their report on title to make sure that you are revised TA6 compliant. Imperative that you understand and your client understands that there's now explanatory notes that accompany the TA6. The seller client should be reading those notes before answering the questions. The explanatory notes should be provided to the buyer because some of those notes are directly relevant to a buyer client. The explanatory notes indicate to the client that where the client is unsure as to how to answer a question, or is concerned that the question is unduly complex, then they should be speaking to their solicitor or conveyancer about how to answer the question. So if you note on the explanatory notes, there's reference there to in an irregular boundary, and the client is told if your property appears to have an irregular boundary, then you should consult with your solicitor as to how to answer questions with regard to where the boundary is located. That worries me. It worries me for two reasons. What is an irregular boundary? Is a client going to understand that? And two, if a client comes to you, I'll come to that in a moment, Zara. If the client comes to you and says, well, yeah, my property does have an irregular boundary, what are you going to advise the client to say? Given what I've just said about the problems associated with land registration and boundary identification, I don't think you as a conveyancer or solicitor can say to the client, well, the irregular boundary shown on the plan means that you must answer the question in the TA6 form in the following manner. I think what you've got to say to the client is you've got to explain in the TA6 form what you understand to be the location of the boundary. And I think your task is to check that what the seller has said in the TA6 is consistent with what you see. But what terrifies me is that you actually answer the question on the client's behalf. So, Mr. Client, you need to answer that question by saying whatever, because if you get it wrong, the client could be sued for misrepresentation and you could be sued for negligence. And remember that, as far as the boundary is concerned, the boundary, even if you were able to look at a conveyance and identify it and describe it, that wouldn't necessarily mean where the boundary is today because of the risks such as adverse possession or some form of proprietary estoppel arising, meaning that the boundary is altered. So what I'm saying to practitioners is you've got to reinforce to a seller client the fact that answers to the questions in the TA6 and indeed the revised TA7 are the client's answers, that all you can do is provide some explanation and some guidance as to what the question is asking for. and how the question should be answered, but the actual answer itself can't be provided by you. If you then have a deeper dive into that, where you're thinking about protecting the client and coming up with a sort of snazzy little legalistic response, the not so far as the seller is aware type of response, or the buyer should rely on their own searches, in surveys and inspections, you've got to remember the case law that deals with that issue and says where a legalistic response is provided, there's an assumption that reasonable inquiries were made before the answer was provided. So that's the Orchard Holmes case, I think it is, isn't it? Oh no, it's the William Sindel and was it Cambridge County Council case? It's that one, which was reiterated in the recent case of Rosser and Pacifico, which we've talked about in the past, haven't we? Zara's raised a question. Hi, Zara. What should we be amending in our retainers to say, read the TA6? Well, I think we've got to say to the client, you've got to read the explanatory notes that accompany the TA6 that I'm providing for you, and you've got to make reasonable inquiries before answering the questions. And the reason you're doing that is, one, the TA6 now comes with guidance, and there's an expectation that the seller client has read the guidance before answering the questions. And if you look at Rosser and Pacifico and William Sindel PLC and Cambridge County Council, again, there's a requirement that where there's the not so far as the seller is aware type of response, or the buyer should rely on their own searches and inquiries, etc., it's implied that the seller has undertaken reasonable investigations before answering the question. With regard to the retainer on a purchase, Zara, I'd be saying to my buyer client, here's a copy of the explanatory notes, read them insofar as they relate to you. And the other thing you should be saying in the retainer from a buyer's perspective is, if you have anything to disclose to you by the seller or the seller solicitors or the estate agent in connection with the property you're buying, if you intend to rely on that information, you've got to provide it to me. And the assumption is that in those circumstances, I would be drafting a special condition to go in the contract. Does that make sense, Zara? I'm going to be looking at some notes on the TA6 and TA7 soon. I'm supposed to do it over Christmas time. I just haven't had time to do it, to be honest with you. I will be doing it as soon as I have time. Not that I'll have a lot of time, given what I'm going to tell you about in a moment or two. But hopefully you've looked at the TA6, you've looked at the explanatory notes, you've got on board the fact that you need to amend your retainer and amend your report on title in connection with purchase. Anyone done that already? Anyone not? Has anyone seen the explanatory notes with regard to the TA6? Has anyone looked at some of the questions? Some of the questions are tricky. And remember, there's case law that says where there's a wide-ranging question in the TA forms, then there's an expectation that the client provides a wide-ranging answer. Right, I often get, please ask your client to confirm the boundaries on the title plan are correct. So if that's an additional inquiry, Zara, my initial reaction to that would be conveyancing protocol does not permit you to raise generic additional inquiries. And I would say, please ask your client to confirm the boundaries on the title plan are correct. I think all you can say is, if you get that inquiry, is ask your client, are you prepared to answer this question? And then the client answers that question in their own words. Zara, what I don't want you to do is to answer it on the question on the client's behalf. That's what worries me. Holly did ask, this is Zara again, about the NPAM form and something else on the new forms to do with utilities. Yeah, have a look at the explanatory notes, Zara. And again, my starting point always with the revised TA6 and TA7 is that the initial expectation was that the client completes these forms on their own without any advice or guidance from you. And I think the Law Society has missed a trick here in that now the guidance is saying, if you don't know the answer, Mr. Client, consult with your solicitor. So there's a real sort of mismatch there and a real mixed message, isn't there? And that worries me. And it worries me even more when you start looking at Rosser and Pacifico and the Woodward Fisher case. Remember the closed moth case, which we've talked about before. Because in Woodward Fisher, the seller's solicitors answered the additional inquiries on the seller's behalf. And in that situation, the sellers didn't come clean to the seller's solicitors about what they knew concerning the clothes moths. So the seller solicitors draft a reply to say, well, we're not aware of any vermin, we're not aware of any infestation at the property. And the reality was the seller was well aware of both of those things. The seller was sued for misrepresentation successfully. And the interesting point there is, given that claim, could the seller bring a claim in negligence against their conveyancer? Well, they could try, couldn't they? You know, the argument being, well, you drafted those replies. The defense from the seller solicitors could well be, well, you didn't tell me about what you knew concerning infestation. Paul, hi, Paul. You're not CQS. Can you stick with the old TA6? You only could, but the problem is you're going to get bombarded with TA6 forms provided by sellers, solicitors, or conveyancers that are CQS compliant. And therefore, you're going to have to advise a buyer on content, and you might have a buyer's solicitors or conveyancers who are CQS compliant who are saying, we can't accept the old TA6 form replies that you've provided for us. So just be armed for that, Paul. Okay. Very good. Right. I can skip along. Remember, this is your day and your forum. Does anyone have any questions, topics, or issues that you'd like us to explore? If so, put them in the chat and we'll have a look at them as we progress. But while I'm waiting for that, I want to talk to you about common hold. This morning, the government has published the draft legislation with regard to common hold. There's explanatory notes and there's the draft act itself. And I haven't had the chance to look at it yet. I will be looking at it tonight. And I will be producing some information relating to it shortly. We are currently delivering some training on common hold. There's a series of 3 webinars. Webinar number 1, I think, was last week. Well, webinars 2 and 3, I think, next week and the week after. I will be incorporating what the legislation reveals and what I can extract from what the government has generated today into those 2 webinars. So if anyone's interested, come along to them. I will also be doing more webinars relating to common hold as we digest the materials that the government has been produced. And just so that you're aware, the Law Society has asked myself and a barrister called Carl Frayne from Tanfield Chambers to write a book on common hold. And I've had an email from Carl this morning on the basis that we need to get on with it. Now we've seen the legislation. So more on that later. Zara, district network heating systems. What do people you tell clients about these? Well, again, Zara, you know, you've got to just say to the client, look, you've got to answer the questions contained in the TA6 form as honestly as you can. Sorry about that. You've got to answer the questions in the TA6 forms as honestly as you can. If you don't understand the question, say you don't understand it. If you do understand the question, then you answer it as honestly and in your own words. I think that's all you can do. Okay, to be honest with you. Issue in the news about 60K for a replacement system. Yeah. Again, Zara, you know, your client's not going to be an expert on the topic. It may be that the seller client knows something about it, in which case there's a disclosure made in the TA forms, and that's all you can say. The point I'm making, Zara, is you shouldn't be telling the client how to draft a response to a question about such a system. Because if you get it wrong or you are misinformed by the client and therefore what you say is wrong, the client then is sued for misrepresentation and you're in the firing line as a consequence. How do you access the webinars? If you send me an email, Nicola, I'll send you details. It's ian@iqlegaltraining.com. Send me an email and we'll get you sorted out. Alternatively, visit our website and you can book the courses on there. Anyway, so common hold, just be aware of it. It's not as frightening as you think. It's a variation of freehold. The landlord is replaced by a common hold community association, which is a sort of self-help group of members who are all owners of freehold flats and apartments. There is a common hold community statement, which is in essence the equivalent of a lease, but this is a sort of a document that does 2 things. It regulates the common hold association, so it's sort of a constitution for it, and at the same time it contains duties and obligations which you'd normally encounter in a lease. The beauty of common hold is that an owner of a flat owns the freehold to their flat or apartment. The commonhold community statement is in a standard form. You can have local rules, but the local rules have to be in a set part of the document. And the other thing with regard to commonhold is that there is a commonhold assessment, which is in essence the commonhold equivalent of a service charge. The thinking behind commonhold is that if you don't have a nasty landlord or don't have a landlord, the commonhold association will ensure that the commonhold is run as efficiently as possible at as low a cost as possible. And that may well be the case. The legislation I envisage will permit the creation of a professional director of a commonhold association, and he is going to charge fees, and therefore there may not be quite the saving that you originally envisage. And the other problem is if the commonhold is run by the unit holders, then all the problems that you get with self-run management companies, etc., you're going to encounter with regard to commonholds, disputes, spats, fallings out, and all that goes with it. Exactly that type of issue you're going to see in a commonhold. Zara, yeah, it is, who have handed over to residents without any real guidance as to what to do. So that's going to be the same problem. Yeah, I don't think, Zara, we're going to have a help desk, but it would be a good idea, wouldn't it? My guess is the leasehold advisory service will be doing the heavy lifting on that, I guess. Davina, have mortgage lenders indicated that their stance to take on new commonholds? Not as yet, Davina, but I can tell you from last time around, lenders were told by government, you've got to lend, okay? And they said they would. There was a problem with the old commonhold regime, and that was the risk of a commonhold association as a company limited by guarantee being dissolved, either due to non-submission of documentation or liquidation or something of that nature. And if the commonhold association died, the commonhold, the title out of which the units derived their freehold title, that would die as well. So you'd end up with unit holders that owned freeholds of flats and apartments in a commonhold that no longer existed. I think that what the government has done in the new legislation is created an opportunity for a Phoenix commonhold to arise in that situation. But the problem with that is potentially that if I'm a contractor contracting with a commonhold, and I know that the commonhold association could sort of disappear into the ether and my money disappear with it, if I know that the common holders could create a Phoenix common holder association and just happily carry on as before, I'm not going to be happy contracting with the common holder association, and I'm going to want personal guarantees from directors. So I think they're the issues really that we've got to look out for. But as I say, don't worry too much about that. We can look after you and make sure that you're sort of properly protected relating to what you're saying concerning common hold. But the problem with lenders, going back to Davina's point, was that lenders were saying, well, all right, if the common hold disappears and the title out of which the freehold is derived disappears, what happens to our security? So that was the failure last time around, Davina. Whether or not that's been dealt with as yet in the legislation, I don't know. I'll have a look at it tonight and I can report back. But lenders will, I'm fairly confident, be lent on, just as they were with regard to the Building Safety Act, to lend on commonholds. If they don't, then it's dead in the water. I can tell you on a cursory glance of the documentation, which was literally 30 seconds this morning, the idea of the launch of commonhold will be new schemes only to start with. So we're not going to see the immediate sort of conversion of all leaseholds into commonhold. What we will see, which is what I predicted, is that we will have new builds that have to be commonhold, perhaps starting 27, 28. And then what we'll have is certain circumstances where a conversion from leasehold to commonhold has to take place. The obvious things where leaseholders want to collectively enfranchise, I could see there being a bar on collective enfranchisement unless you agree to then convert into commonhold. I could see landlords who are so sick of attempting to run buildings and not generating a profit, being entitled to convert into common hold if they wish, so to volunteer to common hold. I could see the majority of leaseholders wanting to convert into common hold at some point in the future and being permitted to do so. I could also see where a landlord has claimed a government grant for remediation work for relevant defects, courtesy of the Building Safety Act. I could see the government saying to them, well, we'll only give you the grant or we'll give you a loan if you convert to common hold, which leads me to an interesting point. Lisa will record it and make sure it's sent across to you. If you want, drop me a note, we'll make sure that happens. So yeah, as I was saying, going back to the issue relating to common hold, is that you could see a situation where the government grant is given, but the landlord is told you have to convert to common hold as a consequence of our providing this grant. You're not going to see at some point in the near or medium term the government saying, right, as of 2028, all existing leaseholds must be converted into common holds. You could see if common hold took off for new builds, and in those scenarios where there's a conversion, you could see at some point in the medium term government saying, right, common hold is now working, everyone's familiar with it, therefore, perhaps on a regional basis or perhaps on an age of flat or whatever it is, schemes have to convert to common hold. You couldn't, when flats come up for sale, trigger a common hold conversion because it's common hold for the entire development, not just the property. Okay, so Zara says, yeah, is it like leaseholds where the landlord has disappeared? Yeah, that's the old model, Zara. That was the old model, okay? And that was the sort of elephant in the room, to be honest with you, which when people had common hold explained to them, terrified them, and which terrified me, to be honest, when I was going down doing the training. So yeah, you're right. Okay, so Deborah asks, is the first webinar available? Watch, I think it is. Anyway, leave that. Okay, cyber security. I was at a conference last week. When was it? Wednesday. Council of Licensed Conveyancers, I think it was. Anyway, there was a guy there talking about cyber security and referring to cyber incidents, and it was pretty terrifying, to be honest with you. I thought that if there was a cyber incident with regard to a firm of lawyers, the incident was capable of resolution, and although there would be costs, the costs wouldn't be that frightening. Okay. Now, I have to say that the speaker at the event was working for an insurer, and the insurer was associated with a company that insured cyber risk. So it comes with a bit of a health warning, but they were telling me, and they told the gathered audience, that the costs involved in resolving the issues were huge, hundreds of thousands of pounds. The first situation, which again is interesting, which I'll share with you, the fraudsters had hacked into a firm's internet and website, and what they did was they started looking at a partner's emails, and all they did was just look at the emails. And I think this had happened for about 6 months or so. They just looked, didn't do anything, just were watching the emails going backwards and forwards from this email address of the lawyers. They then found out that the lawyer was going on holiday. And what they did was they created an email address that was very similar to the email address of the partner that was going on holiday. The partner went on holiday, and then the fraudsters sent an email to the clients, and they targeted, I think it was 12 clients, all of whom were due to exchange and complete while this guy was on holiday. And what they said is, so-and-so's away on holiday. There's been an incident with regard to his email, and therefore please use this email, which was the fraudster's email. So they diverted emails from clients to the new email address. I think there was 12 clients that were contacted in this manner, and all of these clients were due to exchange contracts and complete. And then the email came that because of the problem with the old email address and the issues associated with access relating to emails, the firm was changing its bank details, and therefore the deposit money that you're due to send, next week, next Tuesday, next Wednesday, whatever, you need to send as soon as you can. You need to send them to this bank account. Of the 12, I can't remember the numbers, but I think 8 or 9 clients immediately contacted the firm, and the firm didn't know what had happened, but said, no, that's not right. Continue to send to our old bank details. And I think then the firm again didn't realize what on earth had happened, but they said, in fact, don't send it at all. Just hold on till we sort things out. I think that was 8. I think 3 were about to send money and again contacted the firm to say, we're just checking before we send it. And the firm said the same thing. Don't send anything. Back off till we know what's happening. One client sent I think it was £100,000 deposit to the fraudster's bank account, and that money disappeared into the ether. The firm realized that there was a problem, but by that time the £100,000 had gone. The firm was insured, and the firm contacted their insurer, and the firm then instructed lawyers and instructed IT specialists. And it took the IT specialists some time to realize what had happened with regard to emails being forwarded from the partner solicitor's email address to the fraudster's email address. But they found it in the end and isolated the problem and resolved the problem. But when you look at the story sitting behind it, it was terrifying. Members of staff absolutely terrified about sending emails, had their emails have been suffered the same fate as the emails of the guy that was on holiday, etc., etc. So it caused mayhem for the firm. The second one is even more scary, to be honest with you. This was a situation where the firm's systems were hacked. So the firm went in the office on the Monday morning and couldn't access anything. And then they got, it was a ransomware attack. And then they got an email saying, we'll give you all your information back if you pay us £500,000 or whatever it might be. And again, in this situation, what had happened was the firm's server had been hacked. So there were a number of companies that were using the same server or server provider or something. They'd been subject to this ransomware attack, courtesy not because of their systems, but their systems providers' systems, if you see what I'm saying. And what happened on this occasion was, again, the law firm was insured, but this time the fraudsters were saying, we've looked at your family law and private client information. There's lots of really juicy and sensitive stuff there. Unless you play ball with us and pay us what we're asking for, all that's going to go on the dark web. And that will lead to criminals and fraudsters having all manner of bits of extremely confidential and personal information. And evidently what happened in that situation was the insurance company for the law firm asked the police if it was all right to pay the ransom on the basis that the data breach was so vast and the amount of information so sensitive that it was too risky to try and do anything to try and circumvent what the fraudsters were up to. And the problem with that was the money to be paid was to be paid in cyber, was to pay by Bitcoin. Okay. And there was an issue there about money laundering. So, we're paying money to known criminals in Bitcoin, and there's an AML issue. So they required national crime agencies or authority and all manner of different things. But again, it just shows you what a nightmare it is. And what this guy was saying is your firm needs to have checks, etc. And one of the things that could be checked is it possible for anyone to forward emails from the firm's fee earners and staff's email account to another email address? Do you check it? Do you audit it to make sure whether that can happen, whether it has happened, etc.? Can you put or do you have backup systems, so if there's something happens, clients can be safely communicated, and you can safely say, well, even if our main system has been hacked, our secondary system isn't hacked and can still work and deal with it. Really terrifying, to be honest with you. So a good advert for cybersecurity, generally good advert for cybersecurity insurance, potentially, and also quite worrying is the amount of fees you were talking. You talked hundreds of thousands of pounds worth of legal fees, IT experts fees, etc. And if you didn't have insurance, you're going to have to pay that, or alternatively, it closes your business down. Anyone had any issues with regard to that or not? As far as cybersecurity is concerned, have you all got the cybersecurity accreditation? Is it Cybersecurity Plus and this sort of thing? And are your suppliers, does your sort of tech company, service providers, etc., do you audit that to check that they've got the appropriate cover? Because as I said, one of these, this ransomware attack came via a provider of services to the law firm, not directly to the law firm. Scary stuff, to be honest with you. Yeah. Clients' emails being hacked and intercepted. Yeah, but it's scary, isn't it? And just how easy it is to access systems. On a slightly different note, I was talking to someone again at that conference, and they were saying that someone had the partner's car pinched off the drive, and what the criminals had done is managed to clone the car key, and it was electronic key, and the family had their keys somewhere in the house, and what the criminals had done is had this little gadget that enabled them to see or listen to or ascertain that there were car keys in the house connected to the cars that were on the drive, and they were able to clone a key and then drive off with the car. Yeah, that's it, Zara. So this guy was saying that he had a Faraday box in his house now because of this, and he also had a Faraday purse for his car keys while he was on the move. Crazy, isn't it? Crazy world. Anyway, enough of that. Let's scare you even more. Have you seen all this about this chat about SDLT and the need to register as a tax advisor? I think the smart money seems to be, if you're submitting an SDLT return on behalf of a client, you are a tax advisor for the purposes of the legislation. Therefore, you're obliged to register. And the problem is that if you are designating yourself as a tax advisor for the purposes of the legislation, that means that you are holding yourself out as a tax advisor, which potentially could generate liability with regard to advice or lack of advice with regard to SDLT. So again, what people are saying is have a look at your retainer, see how you're dealing with SDLT, and if you are registering as a tax advisor, your client needs to know that all you've done is registered because you're obliged to register, but you're not giving advice with regard to tax. You're simply giving basic advice concerning generalities with regard to SDLT, and you're submitting an SDLT return on behalf of the client. Have you all seen that stuff? I mean, it is ridiculous that you've got, but again, there was an expert at the, they were, but at this conference that I was attending, Zara, the smart money was that no, you were gonna be obliged to register. So just keep an eye on it, please. Next thing, land registry restrictions. Again, our friends at the land registry are telling me that land registry restrictions are the major problem for them. I forget how many 100,000 requisitions are being raised concerning land registry restrictions. Remember my view with regard to restrictions. If you're acting for a seller, when you're auditing the title, if there are restrictions on the title, are you or is the buyer going to be able to comply with those restrictions? If you don't, I think you register with the FCA, don't you, Nicola? I think it is. I can't remember, to be honest, Nicola. I'll dig it out and find out for you. I think it's the FCA. Anyway, going back to restrictions, if you're acting for a seller, all at the title, if there are restrictions on the title, are you confident that the buyer is going to be able to rely on them? If you're not, or comply with them rather, if you're not satisfied, warn them. Warn the buyer, hey, look, there are restrictions on this title. You should think about either disapplication, cancellation, or modification, or I should be making that application on your behalf and agreeing who's going to pay the costs associated with it. But we are coming across situations where there are restrictions on title which are being checked or looked at by the buyer after completion, and then you're under severe time pressure because you've got to get your restriction complied with before your application to register can be properly submitted. And therefore, from the seller's perspective, audit the title. Are there restrictions on the title? If they are, is the buyer going to be able to comply with them? Assess that position. If you're of the view that the buyer is not, then indicate to the buyer, look, there could be a problem with regard to this restriction. We should be contemplating disapplication, cancellation, or modification. Do you want me to make the application, or are you comfortable with dealing with it after completion? Are you going to have sufficient time to deal with it? And therefore, it's a problem. Right, Sarah, just tweak lots of issues in it, but we could consider the wording developers are proposing so that compliance certificate can be given by a conveyancer. That was always the plan, Zara, with regard to restrictions, that a conveyancer could deal with it on the basis that the land registry would find it easier to communicate with the conveyancer rather than a third party applicant who had the benefit of a restriction. And Zara then goes on, got an issue where there's several restrictions. One were developed that saw their interest in the land, but yet the restriction wasn't withdrawn, probably because they already disposed of the land in question. Well, in that situation, Zara, you could disapply, cancel, or modify the restriction. A restriction has to protect an interest in land. If the restrictioner doesn't have an interest in land, you could probably even invite the land to cancel the restriction. But certainly, if not, you could disapply it. And the land registry seemed pretty relaxed about disapplication applications. Cancellation or modification, because of the permanency of the result of the application, the land registry tend to take a little more seriously. So yeah, land registry restrictions, practice guide 19, and there's an annex or appendix to 19, isn't there, that deals with the restrictions in leasehold titles. I don't know if you've seen it. And again, there's guidance about disapplication, cancellation of restrictions, disapplication, a temporary measure, enabling the current disposition to be registered. But the point is, you need to look at restrictions and identify at the start of the transaction, is there going to be a compliance issue with regard to the restriction? And if there is, it needs to be addressed early on in the transaction. Yeah, not done, Paul. That's staggering. I thought applications to disapply were fairly swift. I'd be asking the land registry legal department to have a look at that, Paul. I'm assuming that you're not time sensitive in that you haven't got a priority period with regard to an application that's going to bite you. But yeah, the land registry, as I say, it's quite bizarre, really, in some respects, and sometimes they can be really swift and really efficient, and other times they can't. There's no rhyme or reason. Okay, so talking about that, again, someone was asking me about this yesterday. Notices on a title. I repeat what was my starting point when I discussed with practitioners notices on registered titles. A notice does not validate or legitimize an interest in land. It is simply a statement that someone contends that they have an interest in land and nothing more than that. Does that make sense? So again, and we were looking at this yesterday with someone, if you have, sorry, I'm just connecting my power cable to my laptop. If you are advising in a report on title that a property appears to be burdened by restrictive covenants because the land registry has noted the covenants on the title or they're being protected by notice. That's not necessarily the case, is it? The land registry does not validate or legitimize an interest in land by placing a notice on the title to protect it. All the land registry is stating, in essence, is that someone that appears to have an interest in land has submitted the correct application to us, and as a consequence of that, we are comfortable in lodging a notice on the title. If you think about it, when a unilateral notice is placed on the title, there is an immediate opportunity for anyone interested to seek to challenge it and seek its removal. So the land registry is clearly not validating the interest and saying there is clearly an interest in land, there's clearly an enforceable restrictive covenant, for example. What they're saying is, we're not sure, we haven't investigated it, but the notice will stay on the title until someone comes along, challenges it and removes it. With an agreed notice, there's slightly more protection. There's slightly more protection because either the registered proprietor consents to the notice being placed on their title, or the land registry has had evidence submitted that indicates the existence of an interest in land. That's all down to, I think it's Rule 34, isn't it, of the Land Registration Rules 2003. So if an agreed notice is lodged, you have a degree more comfort that there is an interest in land to which the application relates. If the application was subject to, I think it's Rule 34(1)(c), where the applicant has had to submit to the land registry evidence in support of their application, evidence in support of the existence of an interest in land, which would be a copy of, they say, the conveyance or the transfer relating to a restrictive covenant, or the better example I can give you is where the notice is protecting, say, an exchange of contract. Unless you were able to provide evidence that the registered proprietor consented to the application, you would provide a copy of the contract and a copy of the memorandum of exchange. But with regard to unilateral notices in particular, the land registry will lodge, sorry, the UN1 will be lodged at the land registry. The land registry will then lodge the notice or place the notice on the title as per the application. But the registered proprietor or any other interested party could then challenge it and seek its removal. So just have a look at your reports on title with regard to restrictive covenants. What I want you to say is that the title appears to be burdened by restrictive covenants as per the list, but you haven't investigated whether the restrictive covenants are in fact enforceable or not. Now, if we take that a step further, I'm not for the life of me saying you should then investigate whether the restrictive covenant is enforceable or not. That's a matter for you, and probably depends on how recent the covenant is and to what extent the covenant impacts on your client's objective with regard to acquisition, or to what extent does the covenant impact on value. If you are contemplating investigating the enforceability of a restrictive covenant, be aware of the need to watch to make sure that you're not undertaking investigatory work that would lead to someone coming along to argue that you disclosed the existence of a problem and thus potentially invalidated any defective title insurance that's taken out as a consequence. So do watch out that. What I would say probably the best thing to do is, in circumstances where your client is saying, or you're of the view that this restrictive covenant is important and could be enforceable, is to, rather than sort of investigate to the death whether the covenant is enforceable or not, with all the risk associated with disclosure, is to take out a defective title insurance policy. The other point with regard to notices is Section 77 of the Land Registration Act 2002. Don't know if anyone's aware of this, probably the most underused and little known section of the Land Registration Act. What it says is that if you lodge a notice or a restriction, or you lodge a caution against first registration, you have to have reasonable cause to make the application. In other words, it must be reasonable for you to do so. In other words, there must be an interest in land to which the notice or restriction relates, or there must be an interest in land to which the entitles you to lodge a caution against first registration. If you don't have those reasonable grounds, then A, the application that's made for the notice or restriction could be subject to challenge, but more importantly, if anyone sustains loss as a consequence of the notice, restriction, or caution against first registration sitting on the title, the applicant is liable for that loss. So if I thought I'd exchanged contracts with you today, and I lodged a notice to protect my imaginary exchange of contract today, but the reality is that the exchange was invalid, then the position is, if I lodge a notice on the title, would I have reasonable cause to lodge it? The answer to that would be no. If you then sustained loss as a consequence of that notice being on the title, you could recover that loss from my client. So what sort of loss could you encounter? Well, perhaps you're not of the view that there was any form of exchange with me, and your client wants to exchange with lawyer X in connection with the same property. Lawyer X is going to say, I can't exchange contracts with you because there's a notice on the title relating to a previous exchange of contract. And you say to the lawyer, well, no, that's a mistake. I'm getting Ian to remove his notice. So, exchange contracts and put your own notice on the title. You might have a buyer who's saying no to that. Or you might have a situation where you've exchanged and the buyer is now saying, I'm not prepared to complete because of the notice on the title. And you're saying, well, that's just, the notice shouldn't be there. I'm seeking its removal. You could have a buyer that says, I'm not prepared to complete, and you're in breach of contract because you've allowed that notice to be placed on the title and you're allowing it to sit there. Well, in those circumstances, you could be liable for contractual interest, and the contractual interest could be a loss that you could then recover from me, courtesy of Section 77. Section 77 is really useful as a threat where someone's put a restriction on the title when they shouldn't have done so, or someone's lodged a notice on a title when they shouldn't have done so, or indeed lodged a caution against first registration. But it's quite an interesting section of the Act that's very infrequently used. The first case involving the Land Registration Act 2002 was a case that involved in part Section 77. That was a case called Labatier in Mornington Estates. I don't know if anyone's seen it. If anyone has, it's quite an interesting case and quite a useful case, but it comes to mind because it's the first case that involved Section 77 and an application of Section 77. Okay, anyone got any topics that they'd like to just discuss? I mentioned as my sort of final point, problems with unregistered land. And again, my friend Jamie Winch at the Land Registry, you probably know Jamie, he was saying in another conference that there were still over 4 million properties in England and Wales that were unregistered. The interesting thing was the vast majority of residential registered titles or commercial registered titles were in fact registered. The 4 million sort of default category of unregistered land invariably was farms or estates or trusts where there was no reason for the land to be registered and no likelihood of the land ever being subject to a transaction that would justify or trigger registration. So the Land Registry was encountering problems with regard to this extensive areas of unregistered land being unregistered, and very little that could be done to try and get them registered. Anyway, that, ladies and gentlemen, is my topics. Does anyone have actually time? We've run out of time, haven't we? We've got some stuff that I'm going to have a look at as a consequence of today. Does anyone like any issues or anything you'd like to discuss next time? I'm going to have a look at SDLT and the tax advisor point. It might be good to have someone to talk to us about cybersecurity insurance. Don't know what you think. It might also be interesting to get someone, a professional indemnity insurer, to talk to us. I'm told that numbers of claims against resi conveyances are down by about 6%. I'm told that the market for insurance for resi conveyances is stronger. There's more people in the market, so there's more capacity, and therefore it should be easier to get insurance with regard to conveyancing practices. So there's some good news there, but it might be useful to get an insurer to come along and have a chat with us. But in the interim, all that's left for me to do today is to, first of all, thank you all for attending today. As ever, I've enjoyed it. I hope it's been of some use to you. Have a look at legalmortgage.co.uk, sign up to it, and we'll get the newsletter sent out to you. If anyone wants to subscribe to Property Law UK, please do so. We've got loads of conferences up and down the countryside. Northampton on Wednesday next week, I think it is. Come along, there's still some spaces. Newcastle after that. Then we've got Liverpool, we've got Wales, we've got Southeast, Southwest, all over the place. So come along to those. Talk to Robert about defective title insurance and about what Stewart Title can do with regard to product, bespoke or online product, and talk to Robert about training with regard to compliance, again important. And thank you very much for coming along today. Stay safe, everyone. Speak soon. And I think we've got some bad weather coming, haven't we? But so look after yourselves. Cheers, Angela. Thanks, everyone. Victoria, as ever, thank you. Lovely to hear from you all. Stay safe. Speak soon. Thanks. Bye-bye.